January 22nd, 22 days before the deadline of February 14th. And also received a personal phone call on February 10th from Steve Sanson, 3 days before the deadline, to remind them of the deadline. Kristine Brewer, candidate for District Court Judge, Family Division, Department B, cut that out, responded 5 days after the deadline by her law partner. The panel will vote to keep Brewer in the interview process or to vote her off. So your decision is that since the procedure wasn't, the original procedure was not followed, but subsequently there was contact and Ms. Brewer is here, the decision is whether or not you wish to see her. There's not really much discussion. I'm just going to have to put it to a vote because I think this is what, was anyone here yesterday? I think that something similar came up. All those in favor of allowing Ms. Brewer to participate? Okay. All those opposed? Okay.
I take full blame. I am her law partner. I take full blame. I read every email that we get to Veterans in Politics. I want to thank you very much. We get a lot of emails for a lot of interviews, and I apologize. It was all my fault. I appreciate you letting Kristine have the opportunity to speak. Thank you very much.
Okay.
Sorry.
It is so decided by the panel that Kristine may join everyone else at the dais. And welcome, Kristine. Memo number 2. We're not done yet. So.
Careful. Just do this. Tripwire.
Okay, again, this time, Joseph Scalia, candidate for District Court Judge, Family Division, Department B, responded 7 days after the deadline. The panel will vote to keep Scalia in the interview process or vote him off. It was subject to the same procedure as the previous candidates. I did not repeat the same thing. All those in favor of allowing Mr. Scalia to participate? Okay. All those opposed? Okay, the ayes have it. Is Mr. Scalia here?
I'm already at the
They're
table.
already here. Okay.
You hesitate, it's just lost.
Okay. Well, you know, I have to follow the procedure. This is a little bit bigger panel than we've had. We have been limiting it to 30 minutes, but we're going to extend this to 45 minutes. It's been a long day, and as I'm sure you can realize, the panelists are probably exhausted. But what I'm going to do is still maintain everyone starting off. I'm going to just start at the end and work your way down. No particular order, no favoritism. You'll have a minute and a half, and I'll strictly keep the time to introduce yourself to everybody. And when the panelists ask their questions, they'll have 30 seconds or so. Just keep it to 30 seconds to direct their questions. And I would suggest, instead of, unless it's something that you really feel that strongly about, I would suggest, so more people can ask questions, that you ask certain people to respond, or if you need to, all of them to respond.
Oh, Mr. Chair, before you start, point of clarification. This is Family Court, District Court, right? Family Court Division?
The Department B.
Okay, so that's where our question is going to focus on. Okay.
Yes. So, and with that, you'll have 1 minute to respond. And again, the rules of the road, again, this is an educational forum. Don't engage each other in debate. When you get this many people going, it's a temptation. And believe me, I would love to have a debate, with none other, but the rules of the road here is that it's an educational forum. I will politely, as politely as possible, cut you off. And that way we can get more of the questions in. So, if we can start down at the end, introduce yourself, and we'll work our way down and we'll get to the questions.
You said 60 seconds?
90.
90
for intros. All right. My name is Shanna, and I'm running for Department B. I came to Las Vegas in 1968 when I was 2 years old. I grew up here. I have 20 years of experience as a private practitioner, and 16 of them dedicated primarily to family law issues. As far as veterans are concerned, I come from a family of veterans. My grandfather fought in 2 wars, was shot down in both of them. My uncle retired as a lieutenant colonel from the Air Force, and my cousin is currently a captain in the Air Force. I understand concerns that veterans have, and I appreciate the opportunity for this organization to get to know these candidates and spread the word about what each of the candidates' experience level is and what they can contribute to the board.
Okay, thank you.
Hello, I'm Jane Femiano. I'm a hearing master in family court, and I'm running for Department B in family court. I am a practicing lawyer, have been practicing for close to 25 years. I've been here in Nevada for 20 years. I also have a couple of family members who were part of the military. My father was in the Navy, and my oldest brother was also in the Navy. In family court, however, I am, like I said, a hearing master. So I'm on the bench every day making decisions about children, and specifically children in foster care. So I must make decisions involving custody, adoptions, visitation, sometimes child support. All of those kinds of issues come before me as I decide on a daily basis what is in the best interest of these children. So I'm on the bench, I have lawyers in front of me, I have unrepresented litigants in front of me. So I have all types of situations, and I have a large calendar, so I must manage that large calendar while still being respectful of everybody who's appearing in front of me. I've been a public servant my whole 24 years of practice. Started off with legal aid practice, and then there was work with the Attorney General's office, and then more recently with the county at the Special Public Defender's Office before becoming a hearing master 5 years ago. And again, I'm Jane Femiano, running in Family Court B. Thank you.
Hi, good afternoon. I'm Linda Marquis. I grew up here in Las Vegas across the street from my grandfather. I'm a third-generation Nevadan. He fought in both World War II and Korea. I went to law school here. In fact, I'm the immediate past president of the Law Schools Alumni Association. I serve now as a Justice of the Peace Pro Tem in both Las Vegas and North Las Vegas. I'm also an alternate judge for the City of Las Vegas, and last year the Clark County Commission appointed me as a presiding officer for the new Coroner's Inquest Program, the Police Fatality Fact-Finding Review Board. I also received an award in 2006 from the Nevada State Bar for outstanding community service.
Good afternoon. My name is Joseph Scalia. I've been an attorney in Las Vegas for probably almost 20 years. Done thousands of family court cases. If you plug my name into the database, thousands of them. When you do so many cases, they were ragging on me for not getting my answer back. And I have a trial tomorrow. I had a trial last week. Family law is one of those most interesting areas of laws because you're dealing with people in a way which you're dealing with their most intimate things. Their property, their children, their debts, possible alimony, all of the resources. And it really exposes a lot of raw nerves, which is why family court and family court judges sort of get a lot of heat from people. But I think once people understand the legal system, that will sort of cure a lot of these sort of problems. That's sort of what I want to do here with the experience that I've had trying so many cases.
Thank you for your time this afternoon. My name is Kristine Brewer. I've lived in Las Vegas since 1972. I was 2 years old when I came here. I feel like I'm a lifelong Nevadan, and I am proud that my great-great-grandfather served in World War I. He actually sketched the battle scenes, and my mom was lucky enough to receive a couple of those as an inheritance. And my grandfather was in World War II, and he was a medic for the gentleman who raised the flag at Iwo Jima. My best friend, her husband, is a lieutenant colonel in the Marines, and he has served with General Petraeus, and he is doing a lot of work in the Middle East. He's a high-level specialist. We don't even really know what he does, but we really appreciate his work. I am devoted to family law. It is my passion. It is my life's work. I'm on the Family Law Executive Committee, and I serve as the secretary. This last year, I wrote an amicus brief for the Supreme Court in the Blanco v. Blanco case, and it was actually quoted by the Supreme Court, and that was a great honor, sincerely. Also, I am a parenting coordinator, and that's an unusual or unique position because I am sought when moms and dads can't get along, and I act as a counselor or an arbitrator between them. A guardian ad litem, I represent the children's best interest in cases, and I'm also a settlement master because I believe that when...
I'm sorry.
Thank you very much.
Thank you. Again, just trying to make sure we stay within our time confines and that everything's being recorded and there's a whole labyrinth of calculations going on here time-wise. And like I mentioned on the outset, this is a little unusual. This is the largest panel we've had all afternoon, and unfortunately, it's also the last panel. So bear with us. And Lynn, if you can direct your questions, or that panelists, naturally respond.
Well, I will make my question available to all of the esteemed candidates there. So let's talk about it. How would you take into account a party before you, their status, as to whether or not they are a veteran of the United States military, into account if making a decision from the bench affecting their livelihood, health, freedom, or that of their children? Take it away, and let's see, why don't we start with the gentleman on the left?
That was a very big question. I don't even know where to start in answering that one. I have represented veterans and their spouses. I have represented them pro bono, in fact. I think veterans come to the family court system with special concerns, partly in veterans and active military who have separate, distinct issues. The active servicemen have issues with child support and possible deployment, child custody and possible deployment during the time that a case might be pending. Some of them, things need to be provided so that custodial issues are not addressed while they're away, and that when they come back, they're not stuck with a custodial schedule that is set in stone. So that's one in particular. Also, the disabilities that veterans come home with is also a very big concern and can affect, and it's something that's being fought in the court and how to deal with that.
Thank you. I actually do deal with that regularly in the court where I am. Again, sitting on the bench, hearing cases involving children in foster care. And because of Nellis Air Force Base, unfortunately, I do see children being removed from the military out there on the base. So we have to deal with the Soldiers and Sailors Act that Shanna's talking about. And I have to make decisions about how to place that child, and custody decisions about that child in an emergency situation when a parent, the father or the mother, may be deployed. And so I have to deal with that on a daily basis already. Thank you.
I think that it's important and mandatory that we identify those people early on in the litigation. In justice court and in municipal court, where I serve now, it's important because both court systems have veterans court programs. Judge Hastings and Judge Tobias do a great job, and I sit for both of them. So it's important that we identify those quickly. The Soldiers and Sailors Act affects family court, and also the new rules that were effective January 2014 for active duty members of the military to put in place a temporary order for custody. Those things are important to identify right away. So I would make sure that they're, like Judge Stevens has in his veterans courtroom, a sign that please identify yourself to me or to the bailiff that you are a veteran or active duty, so that we know which rules apply and where to service you best in the system.
Every individual is different, and every individual who appears in front of the judge has something going on. In my experience, people are in family court because they're incapable. They don't have the skills or the resources to resolve things amongst themselves. So by the time you're in front of the judge, like I tell my clients, you've been married, you've been together for 6 months, 6 years, you can't spend 20 minutes figuring this out. By the time it gets to the judge to make a decision, these people have already spoken with each other. They've already spoken to lawyers, and now it's on the laps of the judge. And as a judge, realistically, how much time does the judge have to really assess the situation in front of them? 20 minutes? An hour? And so I think it's very important at that particular instant is to really assess the individual and what is compelling them to get you in front of this courtroom. Is it a fear that they won't ever see their children? Is it a financial concern? Is it a fear of deployment? And once you peel that issue back behind the issue, you can generally get these people where they need to go. And you can actually make arrangements with people. When someone's getting deployed, well, I want custody of my child, Joe, but you're getting deployed in 6 months. What's going to happen then? And part of the job as their attorney or the lawyer say, okay, look, this is the arrangement now.
Okay,
and
I
then,
have to cut you off.
all right, sorry.
Thank you.
Thank you. I've had several military people, and we do identify their needs immediately and their special needs. Sometimes it is a Iraqi veteran who has suffered from combat, and those needs need to be addressed in a sensitive way, and the spouse needs to be able to accept some of those realities. And with the children, like Mr. Scalia was saying, you need to identify, are mom and dad going to be deployed? But there's some new rules in place. Catherine Provost is our military liaison on the Family Law Executive Committee, and she's been working hard with legislation to make sure that it's fair, to make sure that our veterans that are active service members do not lose custody. It's very important. Thank you.
Okay, thank you. And we all realize the difficulty of responding in concise manner and likewise with questions. It's been a long day. But I'm going to continue in the same pattern that we've been to be sure that we're consistent and fair. Kofi.
This is directed to all of you. So seeing as you're with family court, how often are you likely to refer for like therapy and counseling when you have like constant conflict amongst parents, especially when one is being deployed or whatever's going on, especially if they're having mental health disorders and it's causing the issues of the conflict? How likely are you guys, how often are you guys putting them with therapists and taking the therapist's opinion into concern and when you're making your decisions?
You want to start at that end, or you want to start at this end, or your choice?
Well, since we started at this end, we'll start at that end and work our way back.
Thank you very much. As I'm a family law attorney, and I often, for veterans and my military families and even my other clients, recommend that they do seek therapy when necessary. I'm not a psychologist. I do want my clients, all of them, to be as mentally healthy as possible. And those are often tools that we can use with the judges to help decide the best interest of the child for custody and for visitation interest. So that is a very useful tool in the family court. It's a custody evaluation, and there's many experts in the Valley, and there's a court list that has approved providers. So it helps the judge in an informational way. However, I don't think that it should be the end of the discussion, because the judge at the end of the day makes the decision about where custody and visitation lie, not the expert.
All right, now I'm going to hit a nerve and everybody's going to get the chill going up their back. There are very limited mental health facilities in this area. And not only in this area, in this country. What our solution has been for the past 50 years, we've closed down all the mental health facilities, we've set people out in the community, we've medicated them, and then we said, well, you'll be okay, we're going to integrate you into the community. Then there's no follow-up. And then we wonder, why the streets turn into bedlam. There's your answer. So if I'm on the judge, and any judge who thinks they're going to go in there and wave some sort of magic wand and solve all the psychological and mental problems that we have, we can't. We're not going to do it. We don't have the tools to do it. We don't have the resources to do it. What we can do is identify people. I mean, I've gone to court as an advocate. You're not in the psychiatric evaluation. There aren't any resources, and no one has the money to pay for it. So practically, what are we going to do? The Rollins Hospital only has 200 beds. And I called them one time. It serves the entire southern Nevada. That's over 2 million people with 200 beds. Someone's going to tell you, oh, I'm going to go to the judge. I'm going to give everyone the mental health treatment that they need. Not happening. So we have to be more realistic. And what we can really do in some of these situations is fashion results which protect the children. That's all we can do sometimes. those are the resources available. You have to know which cases those are.
Gotta stop it.
I think especially in cases where there's active duty or veterans involved, there are mental health resources available, but they're not always through the VA. U.S. Vets and some nonprofits like WestCare provide those, but not everybody has just access to those resources. So providing that list of resources or providing an open contact with WestCare or U.S. Vets or even Veterans Village helps litigants in front of you know where they can get those resources and where there might be an availability of some type of service for them.
I see mental health issues, again, daily, whether it's on behalf of the parents in front of me or the children who have been traumatized by the abuse and neglect. So I work with therapists daily. They appear in my courtroom and they talk to me about what the issues are. They submit written evaluations that I need to read the nights before to understand what's going on and what the diagnoses are and what the recommendations are. So in terms of services, the ones I'm already familiar with, for parents particularly, are Mojave or Olive Crest. We use those a lot in our courtroom. For kids, I'm used to using early childhood mental health services and Nevada early intervention services. So very familiar with mental health, unfortunately, in my courtroom.
As I understood your question, it was, would we use those services and consider psychological evidence in court? And I think absolutely. Family law is a multifaceted area. Well, sometimes it's not rocket science, but it takes taxes, contracts, pensions, child custody, all the different facets of law. So yes, psychological, there's a mesh between psychology, and it's constantly evolving, and family law. And you have to be up with it. I do believe that experts and evaluators have their place. Therapy absolutely has its place. But at the end of the day, the judge in the family court cannot abdicate his decision-making to an expert. And ultimately, that judge is going to have to take all the facts and assess what's in the best interest of the children and the family.
Okay, thank you. Forrest.
We'll start with Shane. I would like to know what political party you belong to, just work your way down.
Well, I didn't expect that question, but I'll be happy to answer it. I am a Republican.
I'm a registered Democrat.
Mr. Darby, I'm a Democrat.
I started off as a Democrat. I moved to become a Republican. Now I'm a civil libertarian, I think. Waiting for the revolution to start. In the meantime, I have cases I have to work.
I'm a registered Republican, and this is a nonpartisan position.
And that's true.
Okay, I just got to clarify, what, Mr. Scalia, what party are you currently
I'm
registered?
currently a registered Republican.
Thank you. By far the most interesting answer to a one.
There isn't a box yet for what I'm trying to do. So.
Okay. Jason, you're up.
Thank you all for being here. We appreciate this. Bear with us. We're a little punchy. It is the last panel of the day. This question is for everybody. We're going to start with Linda because we start in the middle here. If you don't mind, Ms. Marquis. I'm a 100% disabled combat veteran. I'm retired from the Marine Corps. I have 3 ex-wives. And what I would like to talk to you about, seeing how this is family court, is what is your personal opinion on trying to go after a disabled veterans funds that they get from the VA, which is non-taxable, non-reportable income that we have to live off of because we can't, work normally like we would like to. So what is your personal opinion on going after those funds in a divorce dispute, saying, well, that's part of his income, so he's going to have to give a part of his disability fund that he gets from the VA?
And pension being separate and distinct from VA.
Right, this is
benefits. Okay,
disability compensation, not pension. This is VA compensation.
VA compensation under Rose versus Rose and the Nevada cases that follow it indicate that it is income for purposes of calculating child support or spousal support, but different from a pension. It can't be used as in a settlement, a property settlement agreement. So it is distinct and unique that way. I'm sorry that you have 3 ex-wives.
I'm not.
Well, yes, and that can be difficult, but As a family court judge, I would certainly follow the Nevada law and US law on that subject.
Okay, this is going to be fun. Go ahead, Joseph.
Jason, did you have the 3 XYs before or after you got disabled?
One,
No, I'm serious about that.
no,
because-
one divorce was before the disability, 2 divorces were after the disability.
All right, look, the number one thing that lawyers, that judges do in family court is about money. That's number one. Well, that's number two. Number one is children. It all boils down to what your financial disclosure reform says. I mean, if you're barely getting by, there's a whole body of law about your ability to pay and their need. So, you're going to ask me off of a thumbnail, we shouldn't be impoverishing people as a general rule. Generally, disability income is considered separate property to begin with. So your lawyer should have been in there filing motions to say all this income is exempt, it's disability, it's separate, and it can't be considered.
And I agree with Mr. Scalia that generally the disability is considered sole and separate property, and that needs to be out in the forefront and one of the first things we evaluate. However, for child support purposes, that can be considered. And again, no one should be left without the means to pay their bills at the end of the month. We need to have moms and dads and children in society that are able to care for themselves. And as a judge, that is our duty, and our job is to ensure that there is enough money for the family, because nothing matters more than families. They're the most important thing, and it's all the money in the world that we bring into the courtroom. The judge shouldn't take it away from you.
We go down to Shanna.
Thank you, and thank you for your service. As I understand the law, and regardless of my personal views, I have to apply the law as a judge, as I understand it. The Nevada statutes provide separate property can be used for the support of a spouse, and the Nevada Case Authority also suggests that as well. Keeping that in mind, in alimony, the judge is using a broad array of factors, and ultimately the judge is left with the discretion to make a decision, the equities for everyone involved, the entire family. And I know that there was a AB 271, I believe it was, that they were trying to change the law to clarify exactly what a judge can do. If that is the law of the state of Nevada, I'm happy to apply it. But in the meantime, I believe that it's left with the discretion of the family court judges how to deal with the issue. But certainly with disabilities, that's certainly absolutely something that could be taken into consideration. Like everyone else on the panel, families need to be supported, and certainly the veterans coming back from war due to.
So you've had the law laid out for you, so there's no reason for me to repeat it. But again, all those factors are just taken into consideration, and I weigh all those, balance those all out.
Thank you.
Thanks.
Sometimes it's best to go last.
I know, I repeat what everybody else just said, but it's not necessary.
Yeah, and it was AB 271,
Yes.
rolled through judiciary, and in any event, unfortunately, it did not make it out of committee. Just a substantial.
I'll get you later for that one.
Well, I was the sponsor of the bill.
I know, I'm making sure.
Angie.
What's the biggest mistake that you've made in the last 5 years that's been a professional mistake that's kind of weighed on you, and what did you learn from that?
Who do you want to start? I'm sorry.
Let's start with Mr. Brewer.
Sorry.
I don't want to violate attorney-client privilege, so
Just talk in generalization.
I'll talk in generalizations, thank you very much. I would say one of the biggest mistakes that I made was picking the wrong building to have my law firm in. And I'm sincere, because you know what? It was not ADA. And so it was not accessible for clients in wheelchairs. And that made me feel a little less than. And I didn't want my clients to feel less than. And I would have to meet them at Starbucks. So in order to accommodate that, I have chosen good office space. and I'm able to serve my clients better and be proud of that, because I had a veteran in a wheelchair who could not come into my building, and I was not proud of that. And I've adjusted that. Thank you.
Thank you. Just want to roll straight on down the line.
Trial lawyers, as our egos are bigger than most people, we only tend to gloat upon our glorious victories. However, the mistakes are the ones which really stick in the back of our craw. And sometimes the mistakes are, not everyone gets along, and sometimes you have clients who you don't get along with so well, and a mistake would be to hang on to them well beyond the expiration date. I'll give you an example. Had a lady one time who, she wanted the car, there's only one car. So I go to court, and no, Joe, I need the car, we only have one car, I gotta transport the kids, one's in a wheelchair, I need to have the car, it's a minivan, I got her the car. We leave the courtroom, she's crying. I said, why are you crying? You wanted the car? I got you the car. She said, I didn't want that car, I wanted a different car. I said, this isn't a game show. You don't get to win the car that you want. The judge is gonna give you his car. And a lot of that is client selection, and you sort of get that with sort of experience reading people. That is the biggest practice mistake, and I still do it.
I think probably you look back on some of those jury trials that you lost over the years, and some of them still stick in your mind. Unfortunately, sometimes the problem with the jury system is that we don't know why exactly they decided against us. And so some of those mistakes or non-wins, we don't know the reason for, and you spend nights thinking, what could I have done more? Should I have been less me or more me? Or should I have... there's just 100 second guesses, so I try not to second guess those decisions since you don't know exactly why they didn't go with you.
Again, I handle foster care cases, so I'm making decisions about removal of your children and then reunification of your kids. And your kids have been removed from you because of physical abuse or mental illness or substance abuse issues. So I have a very difficult job and make very difficult decisions every day. So when you ask that question, the first thing that came to mind is a situation several years ago where I did approve reunification with a parent, and the child was hurt again after that reunification. So what I learned from that is just I had to take all those services we were talking about before and really make certain they're in place and that the parents are learning new skills to be practicing with their kids before it's safe for those kids to go.
This is the toughest question I've ever been asked in an endorsement interview. It's an interesting question. Obviously, we all make mistakes. I do remember when I was a young lawyer, maybe a first or second year, and I had a client that was assigned to me, and she was a pain in the butt, and I did not want to deal with her, and I put off calling her back. She ultimately called the attorney that had referred our office the case, and then the partner that I was working for called me into his office and said, what's going on in this case? And I realized then and there that not responding to your clients was the biggest mistake any attorney can make, and sitting on the State Bar disciplinary panel I've been on for 6 years, adjudicating attorneys that get into trouble. And they get in trouble because they don't communicate with their clients. And as a judge, I think that we need to be responsive to the litigants that come before us as if they are clients, and process their case diligently and respond to the system as best that we can.
Okay, thank you. I hear you shaking the martinis down there. Anyway, we're at about 30 minutes. I'm going to do everything I can to get every panelist to be able to ask a question. It looks like we're tracking slightly over the 45-minute threshold, which I'm fine with if they are, if you are. But I think it's important that each panelist get to ask their question consistent with all the other departments. So with that in mind.
Actually, I have to interrupt. We really can't go over the time limit. So if the remaining panelists have a yes or no question that you want to address to a specific candidate or to all candidates, just make it real short and yes or no, because we have 2 minutes. So carry on.
Okay.
Military service members travel all over the world. My question is very simple. What experience do each of you have with regard to international family law and U.S. treaties that affect it?
I just tried 2 Hague conventions in federal, U.S. federal court trials this year, so primarily my international experience would be regarding the Hague abduction of children.
I've also dealt with the Hague Convention in terms of placement of children. I've had a placement of a child with their grandparents in Mexico that we had to comply with the Hague Convention, and placement with some children with their grandparents in South America, in South Africa.
My experience has been with all of those courts in situations where parents who have been accused of crimes or an abuse and neglect system have been deported while those cases have been pending.
I've had clients from Brazil, Mexico, China, a bunch of countries I don't even remember, over 20 years. It's a bad day when you have to start bringing up the Hague Convention, because you know it's going to be a complicated mess, and people very rarely have what it takes to unkink it. So hopefully, you know.
And I've had experience with clients who live all over the world as well, and the concerns that the parents have regarding abductions and looking at the Hague Convention to make sure that the children are safe.
Yes or no?
It's a yes or no, it is.
These are the fast questions.
Okay, so-
Lightning round.
Right. Yes or no, do you believe that a child's opinion should enter into a custody hearing as far as which parent they want to be with?
Yes.
A child,
Child's opinion.
if they're the appropriate age, yes.
If they're the appropriate age and it serves under the standard, then yes.
It encourages parents to squeeze the child. It's an unintended
Can't hear you without a microphone.
Microphone, please.
It encourages the parents who are to exert pressure on the child. So I would discourage it.
NRS 125-480 is the best interest statute, and it says if the child is of appropriate age and ability. So I would follow the law.
Very quick clarification. Can anyone tell us the appropriate age? That seems germane to the discussion.
There's no specific age.
You got it, yes or no?
The judges.
We're done? Okay, we're done, thank you.
Thank you.
Thank you for your time today. We really appreciate it at this late hour.
I want to thank the panelists.